to Intellectual Property 101, the basics. Welcome to Intellectual Property 101. My name is Paul Rossler. I'm an intellectual property attorney at GableGotwals, and I'm joined today with two of my colleagues, Alicia Edwards and Todd Nelson. Before we get into the material, there's just a few housekeeping matters. Please click the hand icon if you can hear us, and I guess if you can't hear us, you won't even know that I'm asking you to click the hand icon. Okay. You can download the presentation after today's webinar, and if you find this webinar very stimulating and exciting, you could also invite us to any holiday parties where we could share the same information. We will email SHRM certification information after this presentation. You can also submit questions that we will answer both during and after the presentation. And then a video of the presentation will be available on the GableGotwals website, but the SHRM certification will not be available beyond today's presentation. What we're going to cover, the basic types of intellectual property, trade secret, which Todd Nelson is going to cover along with copyright. Then we're going to move on to trademark and trade dress that Alicia Edwards is going to cover. Then we're going to move into patents. And then we're going to end with, and I'm going to cover patents, we're going to end with how to secure and protect the rights in these types of IPs, and then some ways to monetize it. So with that, I'm going to turn it over to Todd.
Hi, I'm Todd Nelson. I'll be addressing trade secrets and copyrights. Trade secrets, generally speaking, are information that's not generally known and has economic value, and for which the owner takes reasonable measures to protect and maintain its secrecy. Trade secret could be the Colonel Sanders secret recipe, it could be Mrs. Field's secret ingredients, or it could be the secret formula for Coca-Cola. But it could also be lots of other things. It could be things such as customer lists, manufacturing processes, marketing plans, internal costs and pricing information, and other things. I had a case last year where the trade secret was the composition of metal in a machine. It can certainly be a business's most valuable asset and can easily be lost through theft or disclosure. Reasonable steps to protect a trade secret could include restricting access, such as locking files, using ID badges, and of course good computer security measures, limiting the people that need to know the information, marking it as confidential so people recognize it as confidential, and one that is sometimes overlooked but is one of the most important is having those people that come into contact with the information agree in writing not to use or disclose the information for anything other than authorized purposes. For employees, that can be accomplished through a well-drafted employment agreement. For third parties that you might be contemplating a business deal with, manufacturing arrangements, development deals, whatever it might be, that can be accomplished through a non-disclosure agreement or what's referred to as an NDA. And NDA forms can vary widely. Some can be mutual, some can be only one way or one-sided, some can last for a long period of time, others are very short, and there can be a variety of other terms that really need to be reviewed on a case-by-case basis to ensure that they fit the particular situation. Also, the NDA frequently will only cover those initial discussions between the parties, so if the parties ultimately do decide to enter into, say for example, a manufacturing agreement, it's entirely possible they'll need an additional NDA or other documents going forward to ensure that information continues to be protected. If a company believes that one of its trade secrets has been stolen, such as a former employee going to work for a competitor, which does happen more than one might think, almost all states, including Oklahoma, have enacted some form of the Uniform Trade Secrets Act for which you can sue. But also last year, the Federal Defensive Trade Secrets Act was enacted, which now allows you to sue in federal court and also provides some additional rights and remedies, including an ex parte seizure process, which in extraordinary circumstances you can, without advance notice to the other side, get court authorization for the allegedly stolen materials to be taken back to help preserve the evidence and prevent future harm. So if you have the right circumstances, it's a very powerful enforcement tool. As an example of a trade secret situation, we have the Thomas the Tank Engine litigation, which was the company Learning Curve had a license to manufacture Thomas the Tank Engine toys, and they've been successful with the tank engine toys, but had not been able to sell the wooden tracks that they wanted to go with them. Another company, Brio, which many people recognize as selling wooden trains and other wooden toys, had really controlled the market for the tracks, and Learning Curve just couldn't get any shelf space in that area. So Learning Curve started talking to Playwood and had meetings with Playwood, which were agreed to be confidential, and Playwood, during those meetings, came up with a way to cut grooves in the tracks that created a neat and realistic clickety-clack train sound. But the parties ultimately didn't reach an agreement, and to Playwood's surprise, Learning Curve later came out with a track called the clickety-clack track that had this realistic train sound with these same grooves that Learning Curve had disclosed. And it turned out it was successful in the marketplace for Learning Curve, and Playwood sued and ultimately prevailed in the litigation on that trade secret claim. So I think the moral to the story is that if you are having discussions about a business arrangement, it's important that those be designated as confidential and documented as such. And also that, you know, a trade secret does not have to be something that you have spent years developing and millions of dollars working on. I mean, it could be something that you had a flash of inspiration on, as long as it's something that others didn't know, that it's something that has economic value, and you took reasonable steps to protect, like in this case, the clickety-clack track. Our next area is copyright. And copyrights protect an original work of authorship expressed in a tangible medium. And that could be things such as poetry, novels, songs, movies, computer software, paintings, sculpture, software, architecture, and other things. It's the expression that is protected, but it does not protect the underlying ideas or facts. There are some fair use exceptions which allow limited use for certain educational purposes, for news purposes, satire, and some others. Generally speaking, the copyright protection will last for the life of the author plus 70 years. If Pablo Picasso creates an original painting, then it's pretty straightforward that Picasso should own that copyright in his own work. If, on the other hand, you are John Doe or possibly Paul Rossler working for Acme Co., and you create a beautiful and artful new and original stick figure drawing, the question sometimes arises whether John Doe owns that stick figure drawing or whether his employer owns the copyright to the drawing. If that drawing is within the scope and course of John Doe's employment, then actually the employer, as a work for hire, will own that drawing. Where the issues frequently arise is with independent contractors, and the one that we see frequently is with software development, where you'll have an independent contractor developing some kind of software for your company. And typically the company will believe it owns the software because it paid for it. But unless they've drafted the agreement documents in the correct way, it may be that at best they have is a license to use it and not necessarily even a right to modify it. And so what they need to do is to have a written agreement with the software developer that not only says that it's a work for hire, but would include assignment language from the developer to the company to make sure they can do whatever they need to do with that software down the road. Also, there's a difference between owning a copyright and having a copyright registration. You can own the copyright by being the author or receiving the assignment, but to obtain a registration, you'll have to submit an application to register at the U.S. Copyright Office. You're not required to obtain a registration to own a copyright, but you will need the registration if you have an infringement situation where you need to sue. And there are also benefits to registering early, such as certain enhanced damages and other rights that are incentives for registering the copyright. If you believe your copyright has been infringed, there's typically a two-element test. There needs to be access to the copyrighted work, and the alleged infringing work needs to be substantially similar. There's somewhat of a sliding scale on that protection, such that the greater the access, the less similarity you may need, whereas the less access, the more similarity you may need. And as an example, we have the very interesting Mattel versus Bryant, or we should say Barbie versus Bratz situation, which was a long-standing dispute between Mattel and one of its former employees, Bryant, and then also its competitor, MGA. Bryant worked for Mattel, and before his employment ended, he came up with an early design for what ultimately became the Bratz dolls. And while he was still at Mattel, he was working on these early design drawings. And then after he went to MGA, after his employment at Mattel ended, MGA ultimately developed and marketed the Bratz dolls, which were extraordinarily successful in competing with Barbie and took a tremendous amount of market share. So litigation resulted between all the parties, with Mattel taking the position that as an employee at the time, Mattel owned the copyright in those early design drawings, and that the ultimate Bratz dolls in the marketplace infringed those copyrights. And Mattel's position was that was both through his employment agreement and through the work for hire doctrine. After many years of litigation, ultimately the courts determined that at least on the copyright issue, the Bratz dolls were not sufficiently similar to the protectable elements of those early design drawings. So it's a good illustration of copyright issues between an employer and an employee, and the benefits of clearly defining the parties' rights and ownership as to those things created. And with that, unless there are any immediate questions, I will turn that over to Alicia.
Thank you, Todd. And I'm going to be talking about trademarks and trade dress. Trademark rights can arise in the geographic area where you're using the mark through common law, and then you can also register them with the states where you're using the mark, or sometimes even with the United States Patent and Trademark Office. The trademark is basically a brand or a logo. It can be a word or a design or a combination of both. The important characteristic is that it connects the goods and services that you're selling under the mark with your business. So it's really a source identifier, and that you're the one that's putting those goods in the marketplace. And we've got some examples of trademarks there. You can see like Kleenex and Coca-Cola would be word marks. Pistol Pete would be a design mark, and then Starbucks would be a combination. You can also trademark sounds and even colors, like the John Deere green. And the trademark protects against confusingly similar marks. So if someone starts using a similar mark after your mark, you're able to claim, you have a claim for trademark infringement. But it does allow for fair use. So you can use someone else's mark to just make factual comparisons, or if you need to use the business to be able to describe your business. Say, for example, you have a repair shop where you fix Honda vehicles. You're allowed to use Honda in that way. The trademark rights last as long as you continue to use the mark and the mark doesn't become generic. And what that means is that so many other businesses are starting to use the mark in a similar way that you sort of lost that distinctive element, and it's no longer distinguishing your business as the only source of those goods. And examples of marks that have become generic over time are like aspirin, cellophane, flip phone, and the videotape. I have an example case here. This was Zatarain's versus Oak Grove Smokehouse. And the issue here is Zatarain's had a federal trademark registration for fish fry. They'd had it since, I think, the early 1960s. In connection with the product that was actually used to cook fish. And about 20 years later, Oak Grove Smokehouse put a similar product on the market called fish fry. So the issue here is the later mark confusingly similar to Zatarain's earlier mark? The court found that they were. It's basically the same mark. There's just a change in the letter and that one hyphen. And then because the goods were so similar, that there really is a likelihood of confusion. So Zatarain or Oak Grove really could be liable for trademark infringement. But in this case, the defense of fair use kicked in. The court found that Oak Grove really had to use the term fish fry in order to be able to describe their services or their goods so that they were able to use the mark and they weren't infringing. The other sort of related issue to trademarks is trade dress. And this really has to do with the product's distinctive look and feel. Like the Coca-Cola bottles and the Pepsi bottles, it can be the shape of the bottle. It can be the colors that are used in an advertising or marketing campaign. And it can even be sort of the shape of a building or the layout of a store. A lot of times when you walk into a restaurant or a business, you know what business it is, even if you don't know the name of that place or that store. So that's kind of what trade dress is. It's really a visual trademark. The keys are that it has to be distinctive. You have to be able to distinguish your goods and services and that trade dress from other trade dresses, and it cannot be functional. So it has to be sort of an ornamental thing that's really intended to identify your business and function as a trademark. And then under federal law, you have similar rights as you would for a trademark. So you can sue for infringement of trade dress, and then there's are similar exceptions also to that protection. I think that's all I had for trademarks and trade dress. I'll turn it over now to Paul Rossler to talk about patents.
Todd started out talking about trade secrets, and patents are, in a sense, almost the opposite of trade secrets, in that if you apply for a patent, what you have to do when the requirements to get the patent is you have to teach others how to make or use your particular invention. So a patent becomes a teaching document, whereas in trade secrets, the idea is to not to teach others. And the other difference between trade secrets and patents is that whereas trade secrets protects any information that's not generally known, a patent only protects an invention. So it has to be an apparatus, a device, some type of composition, a machine, or a material. It just can't be an idea or a concept. You have to actually what's called reduce your idea to practice, and that make either draw it out or build it. So a patent protects any new, not obvious apparatus, composition, machine, or process. And there are a couple of things you got to keep in mind here. One is, in the United States, if you come up with an invention, you can tell others about that invention, and you can tell them about it not under an NDA, which means it's no longer your trade secret. If you told them about it under an NDA or non-disclosure agreement, it still is your trade secret. But if you publicly use or you offer your invention for sale more than 1 year prior to applying for a patent, you can't get a patent. You're barred from getting the patent. If we were over in Europe, Europe has something called an absolute bar. And the rule in Europe is to file for your patent first, and then you can tell others or offer it for sale later. So it's file first, disclose later. Here in the U.S., you can disclose it first, but you can't go more than a year before you apply for your patent. And the other thing that you have to keep in mind with patents is that you have to be the inventor. So you can't derive your invention from someone else. You can't call, for example, a patent attorney and say, hey, I saw something that I thought was really cool, and there doesn't seem to be a patent on it, so I'd like to apply for a patent on it. You can't do that because you didn't invent, and one of the requirements is that you must be the inventor. Now, what the patent does for you, if you get the patent issued, and there's no guarantee that if you apply for a patent, you'll get a patent issued, because a patent will be examined by the patent office to see whether, in fact, what you have is new, and to see whether or not what you have is not obvious or inventive. And if you get that patent, what you have is the right to prevent others from making, selling, or using the patent invention. It does not give you the right as the patent owner to make, sell, or use the invention. And the reason for this is that you may have to use someone else's intellectual property rights in order to make your patent invention. One of the simplest examples of this is the chair and the rocking chair. So if you invented the chair and you got a patent on the chair, and I looked at your chair and I thought, well, this chair is really nice, but it would be a lot better if it would rock back and forth. And so I put rockers on the bottom of the legs, and I apply for a patent on the rocking chair, and I get a patent on the rocking chair. Well, my patent is the right to exclude others from making the rocking chair, and your patent on the chair is the right to exclude others from making the chair. I need to use your chair to make my rocking chair. And so I'm either going to have to buy the chair from you or license a chair from you to make my rocking chair. I can prevent you from making the rocking chair, but I still need your chair. And that's why it's a right to exclude others. Now the protection, your trade secret protection lasts as long as you can keep something a secret. Copyright protection lasts the author's life plus 7 years, generally speaking. Trademark protection lasts as long as you're using that mark in business and it hasn't become generic, which is why, for example, Kleenex every now and then will run ads saying, remember, not all tissue is a Kleenex, because they're trying to keep it from becoming generic. Patent protection, however, has a finite life. It's what's called a limited monopoly. So if you have what's called a utility patent, that lasts 20 years from your filing date. So a utility patent actually protects the structure, how the invention is put together, how it's organized. And if you get a utility patent, it lasts 20 years from the date of filing. So if I applied for a utility patent today, and I got that patent issued maybe 2-3 years from now, my patent protection lasts until the year 2037. There are also something called the design patent. That lasts, depending on when you filed it, either 15 years from the issue date or 14 years, depending on when it's been filed. But what that protects is any new, not obvious, or inventive ornamental look of a product. And as an example of that, you can look to the Apple-Samsung battles. Now, the Apple-Samsung battles involved a number of patents, some of which were utility patents, looking at the structure of these particular cell phones and how they were put together and organized. But a number of the patents were design patents. And Apple had a design patent on the iPhone, and that's shown up on this slide over on the right. And really what they were claiming, they had a number of these design patents on the phone, but they were really claiming that rounded look to the phone. And Samsung phone, before the iPhone came out, tended to have a more square, rectangular look to them. And then after the iPhone was introduced, Samsung all of a sudden had this more rounded look. And so in the battle between Samsung and Apple, one of the things that Apple alleged was that the look of the Samsung phone infringes the iPhone design patent. And the test here, it's a bit like the trademark infringement test that Alicia gave you, where trademark is trying to protect you against confusingly similar marks. These design patents, it's almost the test is almost a confusingly similar test. It's along the lines of, would an ordinary observer be confused into thinking that the Samsung phone and its look was actually the iPhone, patented iPhone look. Todd, did I capture that correctly?
I think so.
Todd's more involved in litigation than I am. He knows these tests. And in this case, at least the trial court found that the Samsung phones did infringe that design patent. So that's all we have on patents. Of course, if this is a utility patent case, it would become a lot more detailed, and that they'd have to look at the individual elements of the phones and seeing, well, is the Samsung phone put together in the same way or a similar way as the iPhone, and get actually down into the components. But from a design patent point of view, it's just how do the products look. That leads us to how to secure and protect intellectual property rights, I'm going to let Alicia and Todd jump in here as needed, but one way is contractually, and where appropriate through registration, either a trademark registration or a copyright registration or patent application. For trade secrets, you need to take what's called reasonable measures, including limiting access. For copyrights, you should provide a notice, and for certain things, register. Trademarks, you're best if you, for example, don't call your fish fry product fish fry. Try to make it distinctive. For example, the only reason that I know Starbucks is coffee is because Starbucks has taught me that Starbucks is coffee, and so that's how you build a brand. You want to either give a TM, which means you don't have a federally registered mark, but you're relying on your common law trademark rights, or the Circle R, which means you're federally registered. Trade dress, you want to make that distinctive. That's your product packaging, your service packaging. And then for patents, you want to apply for patent no later than 12 months after your first public use. And if you're in a business where you might want to have patent protection in Europe, then you better apply before you have any public use or public disclosure offer for sale. And then how to monetize your intellectual property. It's like real property. It can be sold outright, it can be leased, it can be held onto and used in different ways, but it's very similar to real property. You can, for example, license it. You can either give exclusive licenses or non-exclusive licenses. You can limit what those licenses allow the licensee to do. And so with that,
open it up for any other questions. We do have one question, which is, can a name or logo be protected based on the fact that you've published and used it but never filed any trademark paperwork? And the answer is yes. Preferably you put the TM designation on it so people recognize that you're claiming rights to that as a trademark or service mark. But even without a federal registration, you can accrue rights, what are called common law rights, through your use of the mark. Now you're going to be limited to some degree to the scope and extent of the trade area that you've made use of the mark in, which is one of the benefits of the federal registration, giving you rights and putting people on constructive notice throughout the entire United States. But the answer to the question is yes, that you can accrue protectable rights in a mark through the use without getting a federal registration. Any other thoughts?
Really only that you are probably limited to the area where you're using the mark, and whereas federal registration would give you the right, sort of the nationwide right to use that mark.
Yeah, and that's where trademark, for example, differs from patents. For patents, if this is an invention and you've been using it for a long time, then you couldn't apply for your patent. Of copyright, Todd mentioned, your copyrights. You get your rights in your copyright when you express it in that tangible medium. And the sooner you apply for federal registration of a copyright, the better, because if you file, for example, within 3 months of you publishing it, you get access to what's called statutory damages, where you don't necessarily have to prove your damages, but the court can assess certain damages and allows you to get things like attorney fees. But even if you hadn't done it within 3 months of publishing, you can still apply for your copyright years later. You just lose out on some of these other benefits.
One other follow-up to the question about the unregistered trademark use is also, while you accrue rights through the use, you can also lose those rights through non-use. So if you cease using the mark particularly for a period of years, you can be deemed to have abandoned those rights, and others could then step in and start using that mark.
Another issue that we see occasionally is over time, the way you're using the mark will change, especially in design marks. So if you change the design substantially enough that it no longer matches that original registration certificate, you could lose the rights there as well, because you're not able to show that you're using the mark as it was originally registered.
Right. No, I guess there are no other questions, so we thank you for joining us today. We appreciate your time, your attention, and if you have any questions that come to mind after the seminar, please feel free to drop any of us an email. Oops, went too far. And we've got our contact information here on the last slide. So once again, thanks.